Welcome back. What a crazy day. What a crazy week. It's been an emotional roller coaster, up and down. What's going to happen? The budget. We're about to see all these new laws. It's crazy. Virginia is a crazy place for politics, especially this time of year. Who would have thought? So, we're going to do a quick show today to just go through some of these crazy cases and some things that you can expect to see soon. But before we get started with today's great show, please make sure you follow on Facebook, Rumble, or YouTube. You can catch all of the live shows there. That way, when you hear about great stuff and you're talking with your friends and they're like, "Wait, man, you seem to really know what's going on. How do you know all this stuff? Where are you getting this?" They're like, "Dude, I watch this guy's live show on TikTok." And they say, "Man, I don't even have TikTok." You say, "That's fine. You go to Facebook and you follow Vince versus everyone." That's Vince vs. everyone. And it's all right there for you. So we'll go ahead and get started. Philip Van Cleve of Virginia Citizens Defense League posted today about the major victory in the Lancaster County Court. So today, the Crump v. Katz case was heard in Lancaster County, or rather, the preliminary injunction hearing happened today. It was supposed to happen on June 12th. But after the Virginia Supreme Court convened a three-panel judge, they convened a panel of three judges to determine if all of these cases against State Superintendent of the Police, Colonel Jeffrey Katz, he had like 4 or 5 cases against him. So they convened this panel to see if those cases were similar enough to be consolidated into one court. They gave extra time. They delayed the hearing by almost 2 weeks, and we are right up against the deadline for the new SB 749 to go into effect. And for those of you who maybe you don't pay attention, maybe you're not super focused on this issue, SB 749 is what's being called the Virginia assault weapons ban. So, like I said, the initial hearing in the Lancaster County case was supposed to be on June 12th, and that was basically seeking an injunction and hopefully stopping the SB 749 from taking effect. They cited irreparable harm, that banning magazines over 15 rounds is a constitutional violation of both the national constitution, the Second Amendment, and the Virginia state constitution, which would be specifically Article 1, Section 13, both of which guarantee a citizen's right to keep and bear arms. The state's defense of this is that basically this is a militia-tied right, that because of the language in these statutes, that this isn't about an individual's right to keep and bear arms. This is about basically if you're a member of a militia, then like maybe you should be allowed to keep certain weapons. Obviously, this was a fairly weird and weak defense. This is one that's often leveled against Second Amendment critics. It's not a particularly novel argument. It kind of strikes you like that at first because it's happening in the Virginia State Court, and then you realize the Second Amendment is based off of Article 1 from Virginia, and almost the exact same group of people were writing both of these documents for guarantees of rights in the state and then guarantees of rights in our early young nation. So it's really no surprise that they would try and codify this language and force people into these groups. And the reason for that is because the idea of just individual people that maybe want to be able to protect themselves, if you live in a rural community, if something's happening on your property, what they say, when seconds count, the police are just minutes away. If you live out in Tazewell County, if you live in Rockingham County, if you live in Dinwiddie, you're not exactly close to the nearest police station. If somebody runs up on your house, you'll be lucky if the police show up in like 15 or 20 minutes in most cases. I mean, I live in Tidewater, Virginia, which is a lot more populated than all those places I just named. And even where I live, I mean, if you call the police in an emergency situation, you're still talking about a 7 or 8 minute response time, which, to be fair, most people, maybe you've never gotten in a fight. Maybe you've never been in one of these really high pressure situations before. And that's totally understandable. If you've managed to avoid these, it is likely because you've made the right decisions and avoided trouble. But sometimes these things befall you even despite your best efforts. seconds count in these situations. Like it's not like the movies. Even if you just get in a fist fight with somebody, it's not like, this 7 or 8 minute brawl where people are taking breaks to like chat with one another, and flashbacks and all of this that are these huge action sequences. No, like most gunfights happen in a matter of seconds. Like most fights in general are only a matter of seconds. Things happen very quickly. And if your door flies off the hinges and 2 or 3 guys run in your house trying to take your stuff, I'll tell you, 7 or 8 minutes is going to seem like an excessively long time if you manage to get to your phone. No, people in this country, one thing that makes America so unique is that people do have a right they don't have to outsource or rely on somebody else for their personal defense. That is a distinctly American thing. You have a responsibility to protect yourself. And this is something that in Virginia, people should take very seriously. That's why it is in the Article 1 of our Constitution. It was the first thing. It was the first thing in there. Now, Section 13, but I mean, still, that's fairly high on the list. First article. So this preliminary injunction is valid at least through the end of this year or through the conclusion of the case. So they're going to be having a case in Lancaster County to determine, is SB 749 constitutionally legal in the state of Virginia. I will say, based on the original defense offered by Colonel Jeffrey Katz, their case sucks. The whole militia tied thing has always been flimsy. It has never been precedent. That we have loads of historical documents, the Federalist Papers. We have, even in Virginia, we have writings from the founders to one another, articles they wrote to their local papers, things that they wanted people to read and understand. We know very well that this was not specifically for people in a militia. And in fact, if you were to take a stance that's more similar to the founders, it's very likely that they would have arms as a requirement, that you would be required to have some ability to protect and defend yourself, because it should not be your neighbors or your government's responsibility to protect you, at least not the first line of defense. Maybe they do have an obligation as a good Samaritan to intervene in some situations, but frankly, it's irresponsible, to say the least. It is irresponsible. It's the same as leaving your house with the oven on. Well, we have a fire department. I mean, come on. It's like, no, dude, you have a responsibility to handle these things safely and to know how to use them, because you are your own. You should be your first line of defense. It's simple as that. But this enjoinment against the state police prevents them from enforcing the new law. So that means that the magazine ban, the public carry ban, and sporting style rifles, the definition that was offered in the bill, none of that is going into effect on July 1st anymore. You can still buy an AR-15 on July 2nd. Look at that. Look at that. And Senators Saddam Salim of Fairfax, Virginia, he did have something to say. He was a patron of the bill, SB 749. So he championed this through the Senate. And he said that it was disappointing but not surprising, which is wild because I'm actually completely floored. The last 2 nights in a row, somebody asked me what I thought the odds were that we would get an injunction before July 1st, and I said 75-25. I thought there was no way that we were going to see an injunction before July 1st. I thought for sure they would allow the law to go into effect, because the last time we had an unconstitutional gun law in Virginia, it stood on its own 2 legs for 4 years before it was permanently enjoined, and then they dissolved the injunction. So I mean, like I said, they color me skeptical. Like, that how is that my fault? I'm reading the room here. You know what I mean? But Senator Salim, he ends his statement by saying, "I'm confident higher courts will uphold SB 749. This tells us 2 things. 1, he expects that they are going to lose their case in Lancaster County. 2, they are already planning on an appeal, which means that this is going to become massively expensive. This is going to become just like the redistricting thing in Virginia. You can expect them to blow $100 million on this case." And honestly, there is a part of me, I'm a little conspiratorial personally. All these cases come at a time just after the federal government basically shutters USAID. So what we now know was just a front to send money all over the place, and then that money would make its way back to America through NGOs, and then would make its way back into political campaign contributions through those NGOs domestically. We know that that was the old system, and now that doesn't exist anymore. So you have to find another way to launder taxpayer dollars back into campaigns, because that's the game. That's every politician is a millionaire, and it's not all insider trading. These campaigns are businesses. They, in and of themselves, they are a business. So that being said, you have to figure out, how do you get the taxpayer money back? How do you get the money out of the public coffers and back into your campaign? Because that's always been the game. You hire an expensive law firm, like the most expensive one. You pay them so much money, just unbelievable sums of money, and then they can just donate to your campaign, or they can found a super PAC that's parallel to your campaign. It's that simple. What we're watching right here, all of these unconstitutional laws, I mean, this particular legislature and governor, they're like, what are they, like 0 for 4, 0 for 5 now? Like every single one of these landmark bills that they keep trying to get through, they're getting challenged, and they're more than happy to go and stay in court. And it's all just to keep that money train moving, because then they control the attorney general's office. They can just go ahead and get that money and go ahead and shovel it directly towards their preferred firms that can support their PACs. It's that simple. Even in the new budget, they approved, what was it? I think like $70-80 million to the attorney general specifically for enforcement of these new laws. So some of that money is good faith going to go to policing. It's going to go towards different IT infrastructures, or using AI to crawl through all of the 4473s, all of these tools that they have. They're going to use some of that money for that. But they know that what they're going to do with this money is they're going to spend it in court on expensive lawyers that will then donate it back to them. It's that simple. So we can look forward to Jay Jones having a massively losing track record and being able to get the funds out, extract funds from Virginia as efficiently as possible, because that's the game, right? Now, it is worth noting, it is definitely worth noting that this injunction applies specifically to Virginia State Police. At least that's the wording, right? So that means that Virginia State Police will be unable to enforce the ban. If you're in a county with a sheriff's or Commonwealth's attorney that is not going to be enforcing this law, you're safe, because now even Virginia State Police won't be able to come where you are and enforce. However, it is worth noting that in the meantime, these people are highly motivated. They will be happy to make an example out of anyone. And I do not wish on anyone, anybody listening right now, anybody listening in the future, I do not want to see your last name versus state of Virginia on anything. Nobody wants that. No, you do not want that. That is a massive headache. That is a huge financial strain. That is weeks or even months in jail before some Republican PAC group like Virginia Citizens Defense League decides to help you fund your defense, because these people have virtually unlimited resources to make an example out of you. So I do say that. I really appreciate the spirited comments that I've seen on all of these videos, whether I'm blackpilling, whether I'm giving good news, whether I'm warning people about where these things lead. Every single time you see the same message: shall not be infringed, I will not comply, all of these things. And in spirit, I am 100% with you. I do believe that mass noncompliance is one way to overturn these laws in the long run. That's exactly what happened with weed in America. To say nothing else. But similar to, if you look through the history of marijuana enforcement, there are people who spent months or years in jail. They spent tens of thousands, even millions of dollars trying to defend themselves, trying to fight for their freedom, trying to fight for what they thought was right. And Now, you can feel however you want about weed. I mean, personally, I don't know. I think judging by the results, maybe legalization was a mistake. But that is a conversation for a different podcast. What I am talking about is mass noncompliance, and then flaming yourself, putting yourself on blast on social media is like what not to do when committing a crime. Like, that is literally number one. You don't do that. Don't go on Facebook and, joke about how you lost everything in a boating accident, or that you always buy your guns in personal sales and you're not going to comply with the new laws. These are not the kind, like, you're just testifying against yourself. It has never, ever, ever been easier for a prosecuting attorney to crawl your entire social media history. They don't need an intern. They don't need some underpaid, stressed out paralegal to do it for them. They can do it themselves with the single click of a button. So just think about that before you go and create evidence against yourself, because there's no coming back from that. Now, again, this enjoinment only applies to Virginia State Police, back on the original topic. This only applies to Virginia State Police, which means if you live in Nova, if you live in Richmond, if you live in one of these very Democrat cities, even someplace like Harrisonburg, which people think of as kind of a rural place, but I mean, it's a college town. There's lots of colleges there. It is important to remember that your local police will likely still continue enforcing the law. If they are friendly to this administration or the attorney general at all, it is incredibly likely that they will still push where they can and then find out later if it can be enforced or not. And you don't want that for yourself. So just don't do anything stupid. That's all I ask. Just don't go doing what they call hot boy shit. It's that simple. I won't curse again on the podcast. If your kid heard that, I apologize. But no, yeah, don't go doing hot boy stuff. Like, just enjoy the rest of your summer, Take a concealed carry class if you haven't already. Understand your rights, know your rights. In fact, taking one now would be great because you'll probably have the best understanding of the new laws. If you took it a couple years ago, sometimes it's hard to keep up with the math on these things. It's hard. It's very difficult. So like I said, Senator Salim, he had some stuff to say. And the governor, she released a statement through her spokesperson today as well, not herself, which I found a little odd. You see, she personally made her statement against the bill when it was initially passed. I think it was April 22nd that the Senate and the House had both signed it. And within hours, she had gone on TV. She had a little press conference. I want to say it was with CBS. No. It was WRIC. And she goes on and she says, oh, well, I tried to make amendments because the law is unconstitutional and bans common hunting rifles. She didn't say unconstitutional, but she said that the law bans common hunting rifles, which specifically is brought up in the Virginia Constitution, that it can't be used to ban common weapons. And then she uses the exact same word, common. She just describes those rifles as common. So she already testified against her own bill on the hunting rifles. But it is worth noting the AR-15 is the most common rifle in America now. And it comes with a 30-round magazine. So I don't know how you can say, like, if you're going to take, like, the standard magazine and standard firearm in the country and give it some special classification with, for the mag, and then, say that it's not common, we're just playing word games here. It's just word salad. I don't know. They're going to need these laws to come with like pictures and graphics from now on so that way we can make sure everybody, even a bureaucrat, is able to understand it. Maybe if it came with a little comic strip or they put it into a 60 to 90 second video, it'd be a little easier for them to understand. Like, not only do we need the legal briefs, not only do we need the full written opinions on these things, but maybe it'd be good if the judge also did like a 90-second style TikTok so that way we can make sure everyone can understand it. That's just my thoughts, right? Now, weirdly, Dan Helmer, who championed this bill through the House, or rather the companion bill to SB 749, hasn't made a statement yet. I keep updating my page because, like, I don't know. Dan Helmer always got something to say. He did a little 8-mile run yesterday so he could talk about the new bill. And I guess he didn't have it in him to do another 8-mile run today. So he hasn't been able to update us on how he feels about the injunction. I guess that's probably what it is. He can only make the videos while he's doing 8-mile runs. And because he just did one yesterday, we're going to have to wait until either tomorrow, maybe even Saturday, before he's ready to give us another update. That's my thought, right? Maybe that's what's going on there. Give the guy some credit. 8 miles, that's pretty tough. It's tough to do that 2 days in a row. Maybe you should go for a walk. They say you burn more fat walking. But no, so we had another case today, right? That it was the Spiro and Brown represented. What was this case? Give me 1 second. This was Yeah, this was okay. So no, we had some more info from the actual arguments in the injunction hearing. Excuse me. So, what was it? They are not just common; they are ubiquitous. That's how David Brown of Spiro and Brown, who was representing the plaintiffs today, that's what he told the judge. The challenged statutes in this case concern some of the most commonly used arms and magazines in the nation. Yeah, nailed it. That's literally the argument. Good job, man. That's anybody's lawyer right there for this case. Now, the Commonwealth argued that the guns included in the ban are akin to military weapons that are especially dangerous. Martin asked why the ban doesn't apply to all military weapons, including M1 carbines and handguns, which remain legal. The Commonwealth argued that the plaintiff's theory would essentially give Virginians the right to bear any arms, including grenade launchers. It's funny that you mention it. You actually can. If you fill out a Form 1 or a Form 4 and you pay your $200 tax stamp, you absolutely can. It's called a destructible device. So, yeah. I mean, the people arguing against this stuff, they don't even understand. And that's part of why I say I am certain, I am 100% certain this is just a tax dollar scam. Because the people that are arguing against this stuff, either they are too dumb, or they just are too ignorant, or they are intentionally throwing the case, right? We saw the same thing with the redistricting arguments. The California attorney that came here to argue Virginia law, and he's like, well, if Virginia doesn't allow redistricting in this for these reasons, that would make us unique to every other. That would make the state unique to every other for these reasons. That would make us unique to every other. That would make the state unique to every other state in the nation. It's like, that's just we just sprinkle that on top for fun. I don't even know that means anything anymore, calling yourself a Commonwealth. So, no, so this, the arguments were, they were interesting, I guess. But they were they actually do a very good job summing up the divide between the left and the right on this issue, just kind of generally. We got to see the argument an entire nation is having in one county courtroom today. Now, this was another fun one. This was on a national level, right? Just in the same theme. The Second Amendment had a banner day. It hasn't been like this since July 4th, 1776. It's been 250 years since the Second Amendment had a day like this. No, so today, the Wolford v. Lopez decision, it was a 6-3 by the Supreme Court of the United States. The Wolford v. Lopez decision, it was a 6-3 by the Supreme Court of the United States. This means even Target is one of them. They have a sign that says no weapons, right? And it's got a picture of a gun. It's got the circle with the little line through it. It tells you no weapons, right? So Hawaii was taking the exact opposite approach, that basically a business would have to expressly allow you to carry a firearm. Even if you were a licensed carrier, even if you were a licensed concealed carrier, you had to get express permission from the owner. Otherwise, it could be treated as trespass. And so the default position was not allowed, right? The Supreme Court said that basically this wasn't going to stand at all. This decision was struck down so that basically an owner has to expressly disallow. An owner has to withdraw the consent for somebody who's practicing licensed carry to be disallowed from their building or property, right? That a privately owned public property like a grocery store or a hotel, these places are not allowed to just default to disallow they with permission. Instead, it's going to be the opposite way. Instead, they're going to have to specifically disallow, like everywhere else in the country. But I was curious, like, so what does that mean in Virginia? Like, for a store like Target. Okay, so Target has a sign on the door that says no weapons, right? It says don't carry weapons in here. So what does that mean for us now? Are they not allowed to do that? I mean, they are a privately owned public place. For a long time, they've had this policy. And in Virginia, this was a fun little thing I found. This is not legal advice, and not every cop knows every law. So just, take this all with a grain of salt, because if you find yourself trying to defend yourself from the security in Target, then, you don't want to find yourself in the back of a police cruiser. That's all I'm saying. That sign that is posted on the door, it is, let's see, I want to find the exact verbiage here. It has no independent force of law, meaning that the sign alone does not create a trespass situation. So what that means is that if you are in a store that happens to have a sign that says no firearms, then you're not automatically trespassing. Now, if a manager or even a worker in the store says, "Sir, you can't have that in here, you must leave," well, then you need to leave immediately. I mean, they do have a right to kick you out if you're doing something that violates their code of conduct. And whatever that means, whether you get in your car and leave, or, you take it home and come back, whatever, they can't just automatically trespass you. They can't just call the cops after never talking to you, never advising you to leave. They can't just call the cops and say, "Hey, this guy brought a gun, come here and lock him up." They can't do that. Like, the sign itself is a notice of the owner's preference, but the trespass doesn't occur if you remain after being forbidden. So either orally or in writing to you directly, they say you cannot do that here. But basically, this is for privately owned public property. If the staff asks you to leave or disarm, then you must do so. Now, this is distinctly different from federal buildings, so it's worth pointing out. Schools, courthouses, those kinds of things, that's a whole different thing. You cannot bring a firearm in these places still, which is ironic because the Supreme Court, they're in a building where you can't carry, and they're like, well, yeah, but if you go to the grocery store, you need one. And the main argument against this, right? Because you see this, I think that this was part of Gavin Newsom had said something about this earlier today. That, like, the idea that, like, you need to bring a gun to the grocery store for self-defense is kind of ridiculous. But this was actually underscored by a little piece of data. I found this today. This was from what is it called? CPRC, excuse me. So this report that they've had this ongoing for a long time, but today is a good day to bring it up. They found massive errors in the FBI's active shooting reports from 2014 to 2024 regarding cases where civilians stop attacks. Instead of 3.7%, the number that the FBI recorded, the correct number is at least 36%. If you exclude gun-free zones, it is over 50%. So that means in active shooter situations, in gun-free zones, over 1/3 of the time, then those shooters are stopped by a civilian with a gun. If you exclude the gun-free zones from the statistic, it's over half of the time. This is what I'm talking about. This actually brings us all the way back to the beginning about being responsible for your own self-defense. This is why this is so important. Over half of the time. Even if you are somewhere that's a gun-free zone, it's still over 1/3 of the time. The FBI wanted you to believe for 10 years, over a 10-year period, they wanted you to believe that it was an under 4% chance that a civilian with a gun stops an active shooter. In reality, it was nearly half of the time. And when I say nearly, I mean over half of the time. That's insane. When you talk about, well, we have police, what do you need a gun for? Exactly these situations. Exactly these kinds of situations. Now, when you really dig down into the data, right, just looking at this report itself, this is from John R. Lott Jr., who researches gun policy, defensive gun uses, and crime statistics. The way that they collect and analyze this data is through a few different sources. They use like local news coverage so they can identify cases the FBI conveniently left out. They use law enforcement databases for incidents. They cross-reference the local law enforcement reports, after-action reports, and FBI holdings where they have access to them. They look at open source information. They look at whether the attack was stopped by or mitigated. So that means not just that the civilian shot and killed a shooter, but even if the civilian drew a weapon and the shooter runs off, because the FBI doesn't record those statistics. They also found that the FBI frequently would reclassify a civilian as a security guard. You remember that case in Texas where the guy went into the church with a shotgun, and before he got a chance to injure the congregates, one of the ushers shot him down? The FBI tried to classify the usher, who's just a guy at church who volunteers to hold the door at the church. They called that guy a security guard and said, "Oh, well, that's not a civilian." Yeah, I'm pretty sure it is. I'm certain that it is, in fact. So they look at these cases for civilian interaction. They categorize where the FBI makes mistakes, and then they look at these cases that the FBI conveniently leaves out, so they can compile this list. And so they found in just a sample size of they found in a certain window, it was the FBI had 302 incidences. They found 440. And then when they dug down into the data, they found that 157 of these cases were stopped by an armed person who was in a gun-free zone, as opposed to the FBI reporting only 14 of those same 440 cases. If you exclude the gun-free zones, like I said, that rises significantly. So no, I mean, even in earlier periods, they admit they have a harder time tracking data. They have a much better time tracking data because of the ubiquity of social media now. These cases don't just float away. They don't disappear, right? So yeah, they attribute the big difference that they found to FBI undercounting and overlooking rather than quick civilian interventions and occasional misclassifications, right? So it's a very interesting report. Again, that's CPRC. If you want to look it up, I read the title earlier. Again, that is Massive Errors in the FBI's Active Shooting Reports from 2014 to 2024 regarding cases where civilians stop attacks. If you look that, it reads like a legal brief. I don't know what to tell you. Like that's how these studies, they're all like that. But you can look it up. It's very interesting. I specifically remember I was working in a restaurant. It was probably mid to late 2014. I think it was late 2014. And I was talking to the food runner. Great guy. He was such a nice guy. But he was very anti-gun. Even at my most liberal, I was still very much like civilians have a right to own firearms. But he was good guys with a gun, they're actually more of a liability than they are. Well, I guess what, dude? Even from that time, they had already started laying the trap. They were lying to you. And I don't, we don't keep up anymore. Like I said, great guy. But he was just wrong. And a lot of great people are just wrong. That's why I like talking to everyone. That's why the people I love talking about politics with the most are usually libs or progressives, because when you show them something like this, you have a lot of good red meat to dig into, to talk about. And the nice thing about having facts and consistency on your side is that I don't have to be a jerk. They can be as mean as they want because I usually think it's funny. And then we dig into it. We say, well, let's look at the crosstabs. Let's see the statistics. How did they get to this figure? Where did the FBI get it wrong? What do you think about the fact that they overlooked all of these cases? Isn't that a little weird? Doesn't that kind of change things a little bit? You don't even have to ask them to change their mind. You don't ask them on the spot to, you don't say, hey, here's your red cap. You're one of us now. No, but you just say, doesn't that change it a little bit? Isn't it weird that when they said it was 3.7, it was actually 10 times that amount? And that was even in gun-free zones? Which is not even to say, like, what about, how did the criminals have guns in the gun-free zones? Didn't they see the sign? I guess maybe if it was criminal trespass, it would have stopped them. Boom, I did it again. All right, so I think we'll call it there. I managed to stretch this out enough. I got disconnected at one point because the internet here sucks. I literally can't wait to get home. I think I'm going to activate my mobile Starlink so I can make sure I have great internet all the time. That being said, you're not always here for me, but I am always here for you. But I don't want you to feel bad. I don't want you to feel bad at all. If you do happen to feel bad, remember, you can just follow me on Facebook, YouTube, or Rumble at Vince vs. Everyone. That's Vince versus everyone. And, we'll call it even. We'll call it even. And if you're talking to anybody about all these great facts, statistics, great niche, weird local news, Virginia-specific stories, and that people say, man, you really know a lot about Virginia politics. That stuff's really important and underserviced. And you say, that's true. That's why I listen to Vince versus everyone, and you should too, even if you're not on TikTok. Thank you, everyone. Have a good night.